This is Barry Zalma speaking for Claim School Incorporated's blog, Zalma on Insurance. Today we're going to speak about what happens when you're a less than competent criminal. You get caught and you make absolutely nothing from your crime. But failure to profit from a crime of insurance fraud does not excuse the crime, and any conviction for that insurance fraud is almost exclusively affirmed. In this case, an unsuccessful fake accident still sent the criminal to trial. In the People versus Stephen R. Jackson, the California Court of Appeals on January 23, 2025, dealt with Jackson's attempt to have his felony conviction reduced to a misdemeanor because of California's Proposition 47 that basically let criminals steal as much as no more than $900 and not get arrested. In 1992, Jackson was charged by information with conspiracy to commit insurance fraud, causing or participating in a vehicular collision or any other vehicular accident for the purpose of presenting a false or fraudulent claim, presenting or causing to be presented a false or fraudulent insurance claim, presenting a false or fraudulent claim for the loss or theft, destruction, damage, or conversion of the contents of a motor vehicle, and preparing a false police report and authorization of medical records, employment records, with intent to present it in support of a false or fraudulent claim. Jackson was convicted by plea for violation of Insurance Code Section 1871.1, subdivision A3, a felony, and placed on felony probation. In 2024, Jackson filed an application to have his felony conviction designated as a misdemeanor. Proposition 47, approved in November of 2014, makes certain drug and theft-related offenses misdemeanors. Nothing in the relevant statute bases the punishment for crime of participating in a vehicular collision for the purpose of presenting a false claim on the value of the property or claim at issue. In addition to alleging that the value of the claim at issue in his conviction should make him eligible for relief under Section 1170.18, subdivision F, which is Prop 47, Jackson argued that he was never given a check, never saw the check, and that he didn't destroy any property or damage any property. Jackson's appeal was based on his conviction for causing or participating in a vehicular collision to present a false or fraudulent claim. He argued that under Proposition 47, which reduces certain property theft claims to misdemeanors when the value is $950 or less, his offenses should also be reclassified since the value of the checks and of his claims were under $950. His key points were that both before and after Proposition 47, Jackson's offense was classified as a felony under Insurance Code Section 1871.1 and current Penal Code Section 550. 2. The legislature intended to treat causing or participating in a vehicular collision for the purpose of presenting a false claim as a felony, regardless of the value of the claim. And 3. The punishment for Jackson's crime does not depend on the claim's value, unlike other offenses under Insurance Code Section 1871.1 and Penal Code Section 550, which are misdemeanors if the claim is below certain amounts. The court concluded that the trial court properly denied Jackson's Section 1170.18 subdivision F petition to redesignate his felony conviction for causing or participating in a vehicular collision or any other vehicular accident for the purpose of presenting a false or fraudulent claim as a misdemeanor. It just didn't work, in my opinion. Since the people of California did away with most of Proposition 47 recently, what was in effect when Jackson was convicted. However, since his crime, auto insurance fraud, is always a felony, even if he was so incompetent that he made nothing from his crime, he was properly convicted and the court refused to change his felony to a misdemeanor. There is no excuse for committing insurance fraud, and even if the fraud failed to make any money for Jackson, he committed the crime and Jackson was properly caught, tried, and convicted because he was an incompetent criminal and must now continue to be a person with a felony conviction. This video was adapted from my blog, Zelma on Insurance, which is available free to anyone who clicks on the URL zelma.com/blog. You can subscribe to the blog and you'll receive notice of every blog posting, usually 5 or 6 a week. And you'll gain access to the more than 4,950 blog postings. Please tell your friends and colleagues about this blog and these videos. They're free, and they too can subscribe. And if you're interested in further detail about insurance, insurance claims, insurance fraud, and insurance law, please consider for a very small fee subscribing to my Substack publications. Thank you for your attention.